Please be seated. We'll hear argument in 22-872, In re Illinois National Insurance.
May it please the court, Mr. Wright will present argument for the relator. The relator has reserved 5 minutes for rebuttal.
Chief Justice Heck, and may it please the court. The three issues that we are seeking mandamus relief on today, that GAMCO has no ability to bring this case, this claim, that the insureds themselves suffered no loss, and that if there is some sort of loss, there has to be a trial under this court's decision in Hamel. All of these relate to the settlement agreement that we'll go over in a minute and its particular terms. But as the court knows, the trial court here not only found that GAMCO has standing and could bring this case, despite the fact that it has no judgment or settlement requiring anybody to pay it any money. The court found that the $220 million settlement number in the settlement agreement, which nobody is required to pay, is a loss, and it's all a loss. In other words, the court just didn't say there's some loss. The trial court said the entirety of the $220 million is a loss. It comes into evidence, contrary to Hamel. It's binding on my clients or relators and cannot be assailed. And finally, of course, those rulings run directly into the Essex opinion, the Hamel opinion, and the provisions of Texas law about following what's in an insurance contract with regard to
Is it possible for you to be right on one of your first two arguments and wrong on the other, or are you necessarily wrong on both or right on both?
Well,
in other words, whether there was a loss and whether there was standing
are two sides of the same coin.
Yeah, I mean, there's a factual question underlying both of those that necessarily goes one way or the other for both of them. Is that true? Whereas the third one, maybe you could be right on the third one and wrong on the first two, or vice versa.
Let me parse that out.
Yeah.
Okay. There's not a fact issue on any of this. I understand. I just want to make sure I'm clear about that, because we're looking at the undisputed terms of the settlement agreement. So 1 and 2 go hand in hand. The GAMCO standing is the opposite side of the coin from the no loss argument. Okay. Now, Hamel we don't need to get to if there's no loss. If the court says there's somehow some kind of loss, Hamel requires there to be a trial, because at the time of this settlement, these insureds were not motivated to keep the number down.
Is that true as to the $25.5 million of defense expenses and the $4.2 million from the prior insurance recoveries?
We don't see those as a loss. That's a different provision of the insurance policy. And so the insureds did spend some money to defend themselves, and they've got a claim.
I thought loss was defined to include legal fees incurred defending against claims.
Well, yes, but
So that's also loss, right?
Yes.
Okay.
So the loss we're talking about, though, is the $220 million. The loss, so in other words, if you want to say that they've got a loss of, whatever the defense costs were, that doesn't mean it's open up to the indemnity amount. So if they've got a claim, and they do have a claim, that we're not disputing, they can bring against the one insurance policy and one carrier that is the primary in the 2013 tower. The primary in the other tower they've settled with. So they can bring their claim for defense costs, and we should be able to defend that. And it would be just the Cobalt insureds, not GAMCO, versus the one carrier, it's Illinois National, and the one policy, the primary policy, on this claim that we should have reimbursed their defense costs. Of course, we have coverage defenses to that.
And what about the $4.2 million that had already been paid, that was being held in escrow, I think?
It was held in escrow. That was from previous settlements. So it's not a loss in the sense that that they had to pay that out of pocket. They received that money. And in fact...
Right, but is that money that that was a loss, and that's why they received it?
they spent that money, okay, so if we want to talk about the definition of loss, loss has to be,
I don't necessarily want to talk about anything. I'm just trying to figure
Well,
out
I'm
if you know, anything in particular. I'm just trying to figure out if there might be a fact issue on how much the loss is that we can't resolve by mandamus.
well, there's certainly not any question that the $220 million is not a loss because nobody's required to pay it. And that's, if you look at, tab 1, we've set out the terms of the insurance, the settlement agreement that says nobody, this money's coming exclusively from the proceeds of this case, that the Cobalt insured's obligation is fully satisfied by what? By not paying anything, by agreeing to cooperate in this case.
Leaving that aside, does Cobalt, they could seek declaratory judgment saying, the insurers owe coverage and defense costs, short of having proceeded to judgment and personal liability in a class action case. So why couldn't they do that now? Leaving aside whether they have any right, GAMCO has any right to pursue directly, or that anything that the settlement agreement does has any preclusive effect on the insurer's defenses as to the amount of damage or loss. But just on the coverage issue, why would the settlement agreement preclude their Cobalt seeking coverage under the policies?
Well, so if you're saying before any of this happened, could Cobalt have sued for a declaratory judgment? I believe they probably could have. But now that they've signed the settlement agreement that says they don't have to pay anything and they're absolved from any liability for the $220 million.
But they do have a duty to cooperate, and part of that cooperation might be seeking a declaration of coverage, which would not eliminate any of the insurer's defenses as to the amount of the loss or whether the settlement agreement properly establishes the amount of loss. But it seems like you're saying, well, sorry, directors and officers, unless you undergo enormous personal liability, enormous in the form of a judgment, you have no ability to pursue proceeds for what I'm positing could be covered claims.
Well, so there's two things. If they just want a declaratory judgment about what the policy means, they would have probably been entitled to that. This is far down the road. But they're not entitled to seek recovery from the insurance companies for money that they are not liable for. And that goes to the definition of loss that's in the policy. They have to be legally obligated to pay.
Do you see this as a oops on their part? I mean, it's just a mistake? They just wrote the settlement agreement wrong? Or
No.
was it a conscious decision do you really think GAMCO intended to let them completely off the hook?
Well, they intended what they wrote in the settlement agreement, but leading up to that settlement agreement, there were a lot of term sheets going back and forth, and every one of those term sheets, until the settlement agreement was signed, said that the Cobalt insureds will be liable in all the term sheets. And, the Cobalt insureds apparently didn't want to be found liable. And so that's not what the agreement says. But, every time this court decides a case, like Essex or Hamel, good lawyers try to see, well, how can we do a one-off or get around that in the next case? And I think this is exactly what has happened here. This agreement, Mr. Entwistle for GAMCO got the best deal that he could, and they're trying to make this fit with those two cases.
So speaking of other cases, what could the settlement agreement have said here that would have conferred standing on GAMCO?
The settlement agreement could have said that the Cobalt insureds are liable for $220 million. And even with the covenant not to execute and the other provisions, if it had said that, that would have conferred standing on GAMCO under this court's rulings. It would not have made it binding on us, of course, but it would have conferred standing.
And to be clear, it could also say, while denying all liability and I mean, like most settlement agreements, the defendant's gonna deny all liability, but in order to buy peace and avoid litigation expenses, we agree to pay you $220 million on these claims. You would agree even that kind of agreement would still create standing.
Right, because
Yeah,
it says,
because they're liable for that amount of
it
money.
says we agree to pay.
Right.
Exactly.
So they don't have to admit to wrongdoing or.
No,
Right.
of course not, and no settlement agreement does. But in order to be a loss, they do have to, agree in the settlement agreement that they're liable to pay, and that's what
Well,
the,
agree that they're liable or agree to pay, because those may be different things.
Yeah.
well, it's, the loss provision in tab 3 says that the insured is legally obligated to pay. So if they say we are legally liable, we are legally obligated, or we will pay, I think those are functionally the same thing. And of course, the Illinois National primary policy, to which these others follow form in that tower, also puts it in the negative, that loss is not an amount for which the insured is not financially liable or are without legal recourse to an insured. And those two phrases,
So a covenant not to execute wouldn't make it without legal recourse?
a covenant not to execute by itself does not do that, because this court and others have said, well, a covenant not to execute is a promise, okay? And a promise can be breached, and then there might be damages and so forth. But if you've got a judgment or a settlement with a covenant not to execute, doesn't mean you don't owe the money. It just means they can't execute against it. Now, even that covenant not to execute, of course, going into the Hamill argument, means that the defendant really had no incentive to keep the number down. And these defendants here did not have any incentive to keep the number down because they didn't have to pay it. And as we pointed out, in fact, before the settlement agreement, they rejected a demand from GAMCO to pay $175 million. But during the course of this negotiation about the settlement, the number went up to 220. If they're not willing to pay 175, why are they willing to have the settlement agreement say 220? Well, because they don't have to pay it.
Right, yeah, it can be $2 billion, and I don't care
Right.
because I don't have to pay. But since you only have a couple minutes left, can I get you to talk about the question of mandamus relief and adequate remedy? I'm struggling a bit here, maybe more than a bit, on the idea that if we grant your client mandamus relief here, how can we do that without opening the door to the idea that mandamus is always available in every case to challenge the denial of a summary judgment motion?
Well, a couple of things. This is not just a denial of a summary judgment. It's a grant of a judgment pre-trial, and not even limited to the orders we put in the bench book. There are 20 separate orders that strip us of all defenses, that hold this $220 million. What the trial is going to be, and this is an answer to your question, because this trial is going to be a complete waste of time. Judge Carter has said in his Hamill order that what remains to be tried is we're going to take this $220 million number, which is a made-up number, okay, matches the insurance towers, but made-up number, and we're going to allocate that between the remaining towers or remaining people in the case. This court said in Prudential that flexibility is one of the chief virtues of the mandamus remedy. And this court has granted mandamus over the years, even sometimes on a denial of summary judgment or a denial of a motion to dismiss. But this case it fits within several of the mandamus principles. One is, like I said, it skews the trial. It skews the trial because now the parties opposite here, who were at each other's throats, are now hand in hand trying to come after insurance money that the insureds are not obligated to pay. They're going to have to come in to court and act like this is real money, when we've got all of their testimony to a person that says they didn't do anything wrong and they don't owe any money under the settlement agreement. It's stripped us of our defenses. There are several mandamus cases, I think Prudential and some even in this past year, that said when you make the trial of something so difficult, and you strip somebody of their claim or their defenses, mandamus is an appropriate relief. I mean, I think this fits squarely in the mandamus jurisprudence of this court for those reasons. The trial court's orders are really kind of breathtaking. Granted every motion, affirmative motion, took out all of our defenses and said the only thing that's left is we're going to see how much of this money we have to pay. I see my time has expired.
Any other questions? Thank you, Mr. Wright. We'll hear from the real parties.
May it please the court, Mr. Entwistle and Mr. Mesches will present argument for the real parties in interest. Mr. Entwistle will open with the first 10 minutes.
Mr. Chief Justice, members of the court, with your permission, I'm going to speak first to the issues that relate to GAMCO, the ripeness issues, et cetera, mandamus generally, and to the extent that we get to it, issues that relate to Evanston v. Adafina and the bar and the evidentiary meaning of this settlement at trial. And Mr. Mesches will talk to loss, although I'm certainly prepared to answer any questions that you have on any of those issues. Justice Boyd, your point on mandamus is an appropriate one here. What we have here is a mandamus related to a ripeness issue that, just by the way that it's been framed by the relators, in and of itself sort of begs the question that you've asked. Because what they've done is said, look, your judgment isn't sufficient, it's not enough to give you standing to raise the coverage issues, but the coverage issues, as Justice Bland pointed out, are clearly ripe. And then the relators, of course, have taken.
A coverage action doesn't give a third party the right to bring a direct action against a carrier. So it can't be just a coverage question. And have we granted mandamus relief even when an insurance carrier was improperly joined on appeal under the no direct action rule? So it is a little bit different than simply ripeness.
Absolutely, Your Honor. I speak in terms of ripeness because that's sort of how the Essex court, sort of looked at the issue. But as a practical matter here, we have a final non-appealable judgment that resolved fully the underlying securities class action litigation that was, of course, approved in a very, what is not a typical process that comes to this court, but is typical in the class action setting.
Right, but the insurers were not parties to the bankruptcy proceeding.
Your Honor, actually, the insurers did appear in the bankruptcy proceeding. They appeared to assure themselves that they would get their premiums paid during the course of the bankruptcy. So they had availed themselves of that proceeding, but they did not object to the settlement there, though they could have. They could have raised issues of collusion, they could have raised issues of bad faith, et cetera. Of course, at this point, they've now conceded that those don't exist here. They also could have appeared in the trial court before Judge Atlas and raised the same objections or issues. More importantly, and Mr. Wright mentioned the $175 million settlement offer, there was a full mediation that the carriers were invited to. Of course, they were on notice. They were given multiple bills. They were given notice of the claims. All of that's in the record below. They refused to fund the defense here. So bills were submitted up to $25.5 million, as you've heard, in, as these cases go, a very hotly contested, complex securities class action that lasted 4 years.
Right, but the coverage action wouldn't be tried in the bankruptcy court. Nobody was ever under that impression.
There's no question about that, Justice Bland.
And so the question is, why taking that settlement and jumping the step of determining coverage is the appropriate procedural way to decide whether coverage exists and how if it exists, then how to determine loss under the policy.
So I'm not sure that we jumped a step in the sense that we have a settlement of the underlying litigation. In the only way that it really could have been settled, to the points that Justice Busby made and Justice Boyd made, this was a situation where the carriers had refused to fund a defense, effectively the same as not providing a defense, the difference being control over who the lawyers are. But they refused to fund a defense, leaving the directors and officers to their own devices. They had multiple notices and opportunities to participate in the negotiation of the settlement and throughout that entire process. And of course, they could have come in later. On that $175 million demand, that was a demand that followed a mediation that they had been invited to. And they were given an opportunity to respond to it because, of course, the insureds had no money. At that point, Cobalt was on the eve of filing for bankruptcy. It made clear to the carriers and to us that it didn't have the funds. The carriers refused to respond. So when they say, well, the Cobalt turned it down, that's not true. What happened here was they refused to fund the defense. They refused to indemnify. They left, as you pointed out, Your Honor, the directors and officers exposed to $1.6 billion in damages. The settlement amount, yes, it is in fact equal to the $220 million in coverage that was theoretically available, but that's only 13.75% of the provable damages. It was the most we could negotiate for.
Is there any provision of the settlement agreement or of any underlying judgment that requires Cobalt to pay the $220 million or any other amount?
The answer to that, Your Honor, is the only amounts that Cobalt had paid was the $25.5 million, and the individual directors and officers paid over, as Justice Busby noted, the $4.2 million in escrow. And other than that, they are obligated to pay all of the monies that are recovered through settlement or through the coverage litigation from any insurance source, including the directors and officers' policies, which they have done. There have been a number of settlements.
There's language in the settlement agreement in which that obligates them to pay any amount that any of their insurers are ever obligated to pay. Is how you would word that?
Basically, yes. What I would say is they're obligated to pay any and all proceeds from any insurance that are recovered by litigation or settlement. They have to pay over into the settlement. So they've got legal obligations to pay the settlement and the amounts of any settlements or recoveries. They're legally obligated to fund and prosecute the coverage litigation. They were legally obligated to pay over the $4.2 million, and obviously to the extent there's recovery of the legal fee, the underlying legal fees, those will be proceeds that will be paid over as well under the settlement agreement. So to the extent that we're looking for something out of pocket, which is not what these policies require, these are pay on behalf of policies, and appropriately so. There would be no point to have D&O insurance that require directors and officers to pay, especially claims like these, securities claims, which often run into the hundreds of millions and billions of dollars, out of their own pocket. That defeats the point. What the Relators have done here is sort of turn directors and officers' liability on its head and said, look, we want to have a circumstance where we're going to say there's no loss unless you pay out of pocket, but we're going to write a policy that says you don't have to. We're going to pay on your behalf. And so what they've done is they've effectively written in this out-of-pocket requirement when there isn't one under the policies, when we're talking about what a judgment has to do here. We have a judgment. The fact that the judgment doesn't require out-of-pocket payments beyond those we've discussed doesn't change the fact that it is sufficient in its finality to give standing to GAMCO to seek a declaration here regarding coverage. Now, where that ultimately lands,
Would it be a more proper alignment, though, if it was Cobalt and the carriers? In other words, what does adding GAMCO to the state court litigation do?
well, and that's a very good question, Your Honor. What it does is it gives GAMCO the ability to follow its rights under the settlement, which is to intervene in the settlement for purposes of a declaration. It gives it the opportunity to get the declaration and obviously to speak to some of the issues that we're dealing with here. Will the case proceed without GAMCO if you decide for some reason that the judgment doesn't confer, standing isn't really the right word, but capacity to sue? Yes, the case will continue. You know, Cobalt and the individual directors and officers will continue in that vein, and they'll pursue the relief below. And of course here, when we talk about this judgment, and I just make this final point as my time draws to a close, it's important to note that the failure to fund the defense here, the failure to pay the defense costs, left these directors and officers in the position you suggested, Your Honor, earlier, that is the position of having effectively been denied a defense. And while there is no duty to defend, there's an obligation that's absolute. The policies use the words will and shall. They absolutely require that the defense be funded. And in that circumstance, this falls more into the Evanston v. Adafina, case structure. And Chief Justice, to the point of your dissent in that case, I would just note that with that obligation to fund a defense, you put it back into the sort of block circumstance, and that hopefully would allay your concerns that were in your dissent.
Any other questions? Thank you, counsel.
Thank you, Your Honor.
Mr. Mesches, we'll hear from you.
May it please the court. This case illustrates precisely why D&O coverage exists: to attract qualified and capable people to serve in the C-suites and boardrooms in emerging and established companies, importantly, without the risk of ruinous personal liability. But what we have heard today from the insurers would vitiate this coverage, and their positions are grossly inequitable. They would block a settlement where they have wrongfully denied coverage and completely abandoned their insurers, where these insurers had notice and an opportunity to participate, but they made a deliberate choice not to do so. So in short, our position here is this: the insurers have created the very distorted dynamic that they complain about, and it is this precise...
Is requiring insurers to participate in a bankruptcy settlement appropriate when there hasn't yet been a determination of coverage?
Right.
If you're trying to really get at the fairness for everybody involved, isn't the coverage question the first question that everyone should work toward resolving and then proceed from there?
Well, I would suggest, Your Honor, that the first question that should be resolved is the defense question, the obligation to fund defenses, because that's the point that creates the dynamic here that leads to all of the problems that the insurers have outlined to the court. Right, so they're not participating in defense, and so at the end of the bankruptcy, where there's no assets in the bankruptcy estate, and the directors and officers are out there with extraordinary risk. Why is that? Well, principally, it's because they've not been defended. There's a number of other things. Now, what I would say, and I agree with you.
The reason they haven't been paid their defense expenses is because the insurer's position is there's no coverage.
That's what they're saying now, but Justice Busby, I want to be clear that is not how the defense obligation works under this policy. It says they will pay, they're obligated to pay defense expenses incurred to defend a claim. There's no question there's a claim here. That is a securities litigation claim, a claim under the policy. If, and that's a front-end matter, if they have a position that later is vindicated in the court that there is no coverage, they have a right under this policy to come back and seek recoupment. Why is it structured that way? But again, because this is a director and officer's policy that's designed to keep these individuals from being exposed to tremendous risk.
So why is there language in the policy that says the right of recoupment is the only remedy and you can't withhold defense expenses if you think there's no coverage, or?
Well, the only language speaks, there's a two-part provision, it's in Mr. Wright's bench book, but there's a two-part provision, and it says they will pay the expenses before the disposition of a claim, except that they can come back later on and recoup. And typically, Justice Buzzy, and you spoke about this in the NRA Farmers case, that if you do have a dispute about coverage, you might do a reservation of rights. There's things you can do to keep the issue in play, but they certainly have the right if there's no coverage at the end of the day. Justice Bland, going back to your question about the bankruptcy, the coverage issues were not determined by the bankruptcy settlement. That isn't our position. I mean, they have lodged a dozen or more coverage defenses, which have been fully litigated by summary judgment in the trial court. Those things absolutely can be litigated. Our point is their ability to claim collusion, challenge reasonableness, all of that is dictated by them.
If they're predominant questions and alignment of interests, their side's interests are not present in connection with the bankruptcy court's resolution of this claim, then how can the bankruptcy court find that the settlement agreement was not collusive as to the insurers?
Right, and the point there, Justice...
It may be that other creditors, it wasn't collusive as to other creditors, but as to the insurers who have this other satellite litigation that's getting carved out of the bankruptcy, how can the bankruptcy court then find, and any litigation that you have over there, it's not collusive between these two.
Yeah, and
for purposes of that litigation too, and that seems like using bankruptcy judgments for a purpose that goes beyond the scope of what a bankruptcy proceeding is supposed to do.
I completely understand, and let me just be clear. We're not saying you take that judgment and then you just domino effect the entire coverage case. That's not our position. What we're saying is, what that bankruptcy judgment shows you is that this is a really unique situation compared to Hamill, compared to Gandy. This is a public, open, rigorous review process that they had an opportunity to participate in, and what you're looking at also is the dynamic that was created by their conduct. That's really our point. They had an opportunity to come to mediation. They were invited. They didn't attend. And they say now it's because of coverage, but all of those coverage arguments have been ruled on in the trial court, and they've been rejected on every single point. The only thing they have left is this lost thing that they've raised kind of on the back end of the settlement, but that wasn't in place on the front end. So
their refusal to provide a defense, it seems to me, can be relevant to the analysis of whether there was an adversarial proceeding leading up to the judgment or settlement. But I'm not sure how it's relevant to whether the judgment or settlement establishes a loss on the part of the insured.
right. So let me.
You're not arguing that the refusal. So they raised three arguments, and refusal to defend, to me, I'm not sure relates at all to the first two arguments. It only relates.
Well, let me suggest. I hear where you're coming from, Justice Boyd. Let me suggest where it does come into play, because what they have done here is they've created a situation where there's allegedly no loss. But why is that? What they're really saying is, to have a loss here, I'm not going to defend you. You go trial a $1.6 billion case in federal district court that's ruled against you on every single issue, and take your chances, and then maybe there's a verdict and a judgment, maybe there'll be a loss. So they've created the circumstances for their no-loss arguments. That's why I do think it is relevant to the inquiry.
Well, I think what they're saying is, or you can go into a settlement in which you accept liability, and then it's just a question of whether you're covered for that liability.
Well, they are saying that, but they're saying that...
Not wrongdoing, but obligation to pay.
Right, and I think they're saying that with a very important string attached, which is that we heard Mr. Wright say it twice this morning. It has to be a payment out of pocket, but that's completely contrary to the D&O policy before the court, which says it's a pay on behalf of policy. And the way the settlement's structured, and I want to turn to the loss question, but just want to say one more thing on standing, Justice Boyd. There was a question earlier on about the relationship between these issues, but I just want to tell the court on page 908 of the mandamus record, footnote 4, the insurers took the position these are two distinct questions, so I don't think they relate to each other in the same way. But let me just turn to the loss question, Your Honor, and our position is that there is a legal obligation to pay under the settlement agreement because it creates an obligation for the insureds to pay over, transfer, you could think of it as a pledge. The only meaningful asset they have available to them in the context of a case like this, particularly given the bankruptcy context. Because remember, not only are they in a situation where the company is, out of business effectively here, they have no right to indemnity against the company, which you typically would have. So what's the asset they have? It's the insurance policy proceeds. And the cases are clear that D&O insurance is an asset of the directors and officers. So let's look at the settlement agreement itself. We highlighted provisions in our bench book, but I'll just point you to a few different provisions, Your Honors. One, it requires the Ds and Os to pay over proceeds from earlier settlement amounts. That was discussed earlier. That's on paragraph 1GG of the settlement agreement we've highlighted. There is a loss documented by virtue of the Cobalt as an entity having paid out more than $25 million in defense expenses. And then, and this is the important point, it explicitly obligates the insureds to pursue a recovery of insurance proceeds and immediately deposit, pay, the act of paying. It does not require out-of-pocket. It requires the transfer of those funds that are part of the prosecution and payment obligation. It reiterates this at paragraph 16 of the settlement agreement, that there is an immediate payment obligation. And finally, if there are any other insurance policy proceeds recovered, any others, then at that point, they have to turn those over to. In short, GAMCO has a right to receive funds under this settlement agreement and under the settlement agreement, and that is completely coextensive with the Cobalt insured's obligation, legal obligation to pay. And the way this settlement agreement is structured, going back to your question at the outset, Justice Boyd, is it's structured so that they aren't paying on their own behalf. The insurance companies are, and there's a legal obligation to transfer these assets to satisfy a massive claim. And I want to just, at the very end, address the mandamus question. I'm telling you, if the court says a mandamus review is available for these summary judgment rulings, there's going to be a lot of really happy trial court litigators who get to come to the court with any kind of summary judgment, grant or denial they want before the disposition of the case. And I don't think this is an appropriate case for mandamus, and we respectfully request the court affirm the results below.
Doesn't standing make this a little bit more unique? Isn't mandamus more accepted in that context?
It can be, Justice Boyd, but can I just make my time's running, one brief comment about that? It is, but if you look at the Essex decision, what the court was concerned about was not just standing, jurisdictional standing. What it was worried about was this being resolved in the context of a contested trial so that the insureds would have to testify against themselves. So there's a prejudice angle, which is completely missing here. There's no allegation of prejudice or anything of that sort. Thank you, Your Honors.
Any other questions? Thank you, Chief Mesches. Mr. Wright, you have 5 minutes.
May it please the court.
So why isn't the obligation of Cobalt to pay any insurance proceeds to GAMCO something the insured is legally obligated to pay as a result of a settlement?
That's a really circular argument that the other side has come up with, because loss is if there is coverage, that is, if there is recovery from the insurance policy, and there can't be recovery from the insurance policy unless there is loss. Loss means, and by the way, I did not say and do not believe that the Cobalt Ds and Os have to pay out of pocket. I say they have to be legally liable to pay. Those are two very different things. They put up this straw man about we're saying this is a reimbursement policy and they have to pay out of pocket. No, they have to be legally liable to pay, which this settlement agreement does not make them.
Well, it makes them legally liable to pay any policy proceeds.
Yes, and to
pursue those proceeds.
to pursue them and to
And
get
pay
some
them
back
over
out of it.
immediately.
I'm sorry?
And to pursue the proceeds and then to pay them over immediately if they get them.
But if they don't get them, then it's not a loss.
How's that any different than a Stour settlement? I mean, when I was defending doctors and they'd get a demand for something way over limits, we would settle for something equal to or under limits, and then with sort of the I guess it was a non-execution agreement or something. I'm having a hard time figuring out how this is different than those situations.
Well, if you settled, I'm assuming you paid money or you agreed to
No.
pay with a non-execution. And I think Gandy and a lot of those other cases may have something to say about that kind of practice. I can't remember in what years you were practicing, but this is that same kind of deal. They get a cut out of whatever they recover against us. That is, Cobalt is a pretty big cut, up to $28 million. So they've got an incentive now to claim that this securities case was so big and bad, that's why we had to do this $220 million settlement, when they've all testified we didn't do anything wrong. This is perverting the system, like this court has talked about many times.
Would you agree that if they're right about what the settlement agreement means and what the policy means and how they interact, that they can win, that GAMCO can succeed on the merits ultimately, if they're right about what these agreements mean?
Well, first of all, GAMCO shouldn't be here. That's not
Even if they're right about how the obligations created by the settlement agreement and how that interacts with the policy.
Well, they are not a settlement creditor, not a judgment creditor. They don't have I mean, if you're asking me if I'm wrong about everything, do I lose? But I think if the settlement agreement can't be read.
That's sort of my point, because if they're right about all of this, if it's true that if they're right about what these agreements mean and how they relate to each other, that they win, if that's true, and I think it probably is, then it seems odd that we're talking about standing. Because the argument is that they don't have standing to bring a claim that if they were to win it on the merits, they'd have a valid judgment in their favor.
Well, not GAMCO. GAMCO is only seeking a declaratory judgment of coverage for Cobalt and the insureds. But that's what this court issued mandamus on in NRA Essex. It's the same thing. They've got it is standing. Some courts have said it may be ripeness. Either way, it's jurisdictional, and GAMCO can't be here. But if they somehow convince this court that this settlement agreement creates a loss and that it creates liability towards GAMCO, then GAMCO does have standing. Then we get to Hamel. And we're going to have a Hamel trial. This court held unanimously in the Hamel case that if there is some sort of settlement or judgment that's non-adversarial, where people didn't have this incentive to keep the number down, like they don't, in Hamel, two things. One, the carrier admitted that they did not defend. They had a duty to defend, which we don't, but that's been talked about. Two, there was a trial and a judgment. And this court said, under those circumstances where that defendant no longer had any incentive to keep the number down, you have to try it all again. So Hamel, if we lose the other points and get to Hamel, they are going to have to prove the underlying securities case in this trial, in this securities case, because that's exactly what Hamel said. They got to prove the liability and damages in order to show any kind of agreement or whatever that should be binding on us. And otherwise, it can't be binding on us.
Keith, if I may, if you are right, say on all 3 points, does there still have to be a trial by the Cobalt and D&Os on any issues remaining at all?
Yes, on the defense.
GAMCO's out.
GAMCO's out, the Cobalt, Ds and Os. I mean, a lot of those defense costs have already been paid, but to the extent they've got some left, they would have a claim against, like I say, one carrier only, not the dozen that are in this case
And
now.
only for defense costs.
Only for defense costs. And that would be a much simpler trial, and that would comport with this court's precedents. I see my time is out.
Any other questions? Thank you, Mr. Wright. Case is submitted, and that concludes the argument set for this morning. Marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.